Welcome to the Legal Zone, your YouTube channel for legal information. I'm attorney Marcia Mignot, and today we're going to cover DUI laws in the state of Georgia. As of February 18th of 2019, the Supreme Court of the state of Georgia issued a ruling in the case of Elliott versus the state that has now made it unconstitutional for the prosecution in your DUI case to enter into evidence the fact that you refused to take a breathalyzer test at the scene of your DUI arrest. Now, the laws prior to this ruling allowed an implied consent to be read to a defendant at the scene of a DUI stop. And the implied consent included language that said that if you refuse to blow a breathalyzer test or to submit to a field sobriety breathalyzer test, that refusal would be used against you at your criminal trial and would be presented to a jury as evidence. The Supreme Court stated that that is improper because the Constitution of the state of Georgia does not allow for the compelled self-incrimination of a defendant. So what that means is that you're not allowed to incriminate yourself, and if you are forced or compelled to provide incriminating information against yourself, that would be used against you at trial, and the jury would be allowed to be told by the prosecution in your case that you refuse to blow. The Elliott case states that such conduct on the part of the state would be unconstitutional because you would be forced to provide incriminating information against yourself. Now, be careful because the breathalyzer is different from the officer's authorization to get a warrant to draw your blood. That is different, and the case of Elliott does not apply to your blood being drawn based on the officer seeking a warrant from a judge, a magistrate judge, to draw your blood. The civil proceedings associated with a DUI case is also not affected by the Elliott ruling. So the Supreme Court held in the Elliott case that it can be used against you in a civil proceeding, but it cannot be used against you at your criminal trial. So keep in mind that if you refused the breathalyzer at the scene, that when you attend the ALS, which is the administrative license suspension hearing, that can be used against you, and a court can determine at your ALS hearing that your license will be suspended based on your refusal to submit to the breathalyzer. So remember that there are two issues associated with a DUI arrest. The first issue is going to be an administrative civil proceeding as it pertains to the administrative license suspension, and the second issue in a DUI case is going to be your criminal proceeding as it pertains to whether you should be convicted at trial or whether or not the breathalyzer results or your refusal of the breathalyzer can be used against you at trial. Remember that you are always to check the laws in your state because the laws in each state as it pertains to DUI differs. You do not want to use the DUI laws or the information we're providing regarding the DUI laws in the state of Georgia if you do not reside in the state of Georgia. If you have a DUI case that is currently pending, you want to make sure you consult an attorney prior to going to trial because your attorney can assist you with this new ruling and how this new ruling affects your DUI case. The Supreme Court of Georgia has not decided to date if this ruling applies to cases where people have been already convicted of DUI, but that decision, I suspect, is going to be coming down the pipes, and I anticipate that the Supreme Court of Georgia is going to address that issue as to whether or not the DUI ruling in the Elliott case is going to be retroactive. That would be serious complications for the state because there are probably a lot, if not thousands, of DUI convictions that currently are on the books or on the record that would need to be set aside. So we're still awaiting a decision from the Supreme Court of Georgia as to whether or not Elliott would be retroactive, and until then, it is not retroactive. Currently, it is going to be applied to cases going forward. So once again, if you've been arrested and charged with a DUI, your case has not gone to trial as yet, and you are pending a trial, you want to consult an attorney immediately because this ruling definitely will affect what is admitted at trial against you. Remember that You can always subscribe and respond to us and let us know what topics you want us to respond to, or if there's any information that we've provided on our channel that you want us to clarify for you, reach out to us and let us know that. We'd be more than happy to address those issues for you. Once again, I'm attorney Marcia Mignot, and you're watching the Legal Zone YouTube channel.